8 Steps to Suing a Debt Collector. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. If you're being harassed for debt and you want to sue the debt collector, you may want to follow these steps. This isn't intended as legal advice, but rather it's one type of analysis you should consider as you make your decision. Step 1. Figure out the status of the person harassing you. Is it a debt collector or an original creditor? Generally speaking, the original creditor is the person who claims you owe it money because of some transaction that occurred between you and it. For example, a utility company might sue you for unpaid bills. On loans, the term original creditor also includes the loan servicer. Debt collectors, on the other hand, are companies that either work for the original creditor but do not have the same owners, or who buy the debt after it's in default, junk debt buyers. Again, speaking generally, your rights against a debt collector are much more extensive than against original creditors. Step 2. What is the action you consider illegal? Remember that you cannot successfully sue someone simply for annoying you. Rather, the point of a civil as opposed to a criminal lawsuit is to seek relief, that's usually money, for some illegal act or acts. If the action in question, for example, is repeated telephone calls at 9:30 at night, that may well be a violation of the FDCPA, the Fair Debt Collection Practices Act. The FDCPA applies generally to debt collectors but not to original creditors, so it may not be illegal for the original creditor unless you can find a state law that makes it illegal. On the other hand, a threat to firebomb your home if you do not pay a bill is likely to be illegal regardless of state for original creditors as well as debt collectors. Some things simply go too far. You can Google the action, your state's name, and the word illegal, and get a feel for whether the action is actually illegal. Or you could do a more systematic search at a nearby legal library, as I explain how to do elsewhere. Step 3. Consider legal representation. Under certain circumstances, this might be step 1, but I'm assuming a certain self-reliance and a normal reluctance to contact lawyers. If it looks like you might have a legal action, you should consider obtaining counsel, a lawyer. The Fair Debt Collection Practices Act, that's the FDCPA, includes a right to attorney's fees if you defeat a debt collector, and other laws, while not always including a right to fees, might be attractive enough to a lawyer for him or her to take the case on contingency. Lawyers often do want some money up front, though. Step 4. Assuming you're going to do this without hiring a lawyer and that you do feel that you have a right to sue, you will now want to do some more legal research. Check out my video on legal research and do some research on the specific actions that you're complaining about. Step 5. Choose your jurisdiction. If you want to sue someone under the FDCPA, you could bring your case in federal district court or state court. If the action is simply under a state law, you will likely be limited to state court. You'll have to consider which court to bring your case in. You'll get help on that in the litigation manual. Step 6. Draft your complaint or petition. Again, how to do this is beyond the scope of this video, but you'll find help in the litigation manual and forms. Step 7. File your petition, obtain or write, depending on what the clerk tells you to do, a summons. Your petition is your statement of facts and law, but the summons is actually officially from the court. You may have to name the corporation and its agent designated for accepting service in the petition or summons, and you will need to know it for serving the case anyway. You can get these things from the Secretary of State for your state. Either call the Secretary of State's office, that's probably in your state's capital city, or go to its website. Look up the company and get its official legal name. That's who you will sue if you're suing the company. And the person designated as agent for receiving service. That's who will be served the lawsuit by the process server. Step 8. Serve the lawsuit on the company. Look up the rules of civil procedure for your jurisdiction or the local rules of your court for who must serve the suit. Usually this will be by an adult non-party to the suit. Some courts require that the suit be served by a sheriff. Others require that it be done by a private certified process server. If you have to get a private process server, call a private detective firm or look up process server in the yellow pages. They aren't expensive. $25 to $50 gets it done. Find the right process server and get the suit served on the registered agent. You are now suing the debt collector. At this stage, you can follow the litigation manual as to the rest of the case, or follow your instincts. Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegallegup.com. Get my litigation manual and forums, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forums. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors on Facebook or YouTube, as these things help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.